And welcome to our scheduled Zoning Board of Appeal meeting. It is our custom, well, first of all, let me introduce one of our newest members to the board, which is Mrs. Gail Murray. I'd just like to take this time to welcome you and thank you for becoming a part of the Zoning Board of Appeal.
Amen.
Thank you.
It is now 5:05. We'll call this meeting to order. It is our custom that we begin by reciting the Pledge of Allegiance. If everyone could please stand, face the flag, and recite the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Are we all okay with the public notice?
Yes.
Thank you. I'd like to make note that before we adopt the agenda, item 6, there's a request that this item be postponed until our next scheduled meeting. So we won't be hearing that case tonight. And
Well, Mr. Chairman, just in case it's necessary, I move that based on the letter we received from Mr. Kuhn, that item number 6, the Haskett appeal, be continued to our next meeting.
okay. That's your motion. Can I get someone to?
Second.
All right, so it's been properly made and second. All in favor? Adopt. So the agenda has been adopted. Approval of the minutes. I know that myself and Mr. Guinness wasn't here on that meeting, so 1, 2, 3. Is Mr. Guinness with us tonight?
No, he is not.
Is he with us via Zoom webinar?
He hasn't come up. I sent him the link.
Just the link, okay. All right, so I guess we will have to move that to our next meeting where we can have a quorum.
And if we could, Mr. Chairman, for Ms. Austin, as far as the minutes go, could you put the time that the meeting adjourned under when the motion was made?
Okay.
I appreciate that. Thank you.
Okay, so item number 7, the public hearing on Adams Outdoor Advertising Limited Partnership appeal, the decisions and deny 11 sign permit application. You can approach the podium and you have 10 minutes to, well, go ahead and no more than 15 minutes to state your case.
Thank you, Chairman Mack and members of the ZBOA for Beaufort County. My name is Jeff Tibbles. I'm with the law firm of Bybee and Tibbles, and I'm here today representing Adams Outdoor Limited Partnership, Adams Outdoor Advertising Limited Partnership, excuse me. This is an appeal of 11 sign permit application denials, and I don't have too much to say other than the appeal forms state the grounds, and so those can be reviewed, particularly in 10 minutes. I can't cover all the ground.
Well, Mr. Tibbles, why don't you just briefly tell us, what the grounds for your
Yes,
appeal?
let
And
me
let me
just-
ask you a question. We got information on 2 of the sign permits. Were all 11 of them denied?
Yes, yes,
Okay.
sir.
All for the same reasons?
Yes, sir, Mr.
Okay.
Williams, yes. Yeah, all 11 were denied under the same grounds. And if I could just give you the timeline and very briefly, on April 27th of 2021, Adams submitted 11 sign applications for digital signs throughout the county. On May 24th, Council of Beaufort County had first reading of a revised sign ordinance. On May 25th, there was a public notice of a second reading and public hearing via newspaper publication in the Beaufort Gazette regarding the revised ordinance. On May 26, 2021, Beaufort County advised Adams that their applications were incomplete, but they did not deny those applications. On May 27th, Adams submitted supplemental information for the existing applications Those were submitted for each of the 11. And so those were delivered to the county on, that was on May 27th and June 1st. There were 11 sites, so one was submitted on May 27th with the updated information, and the others were on June 1st. On June 14th, council gave second reading and public hearing on the revised sign ordinance. On June 24th, the applications were denied on the basis of the old sign ordinance that was in existence. On July 8th, the Planning Commission approved the revised ordinance, and on July 26th, council had third and final reading of the revised ordinance. And so these sign applications were denied, all 11 under the old existing Beaufort County sign ordinance, which was subsequently changed. The grounds for the denial are stated. They are in the record. There's a letter for each of the 11 sign appeals of the sign permit application denials, and those are all in the record. And the grounds for the appeals are stated in the appeal forms as well. I understand there may be a question as to whether or not this body has jurisdiction to hear some of the grounds, but that's...
And which grounds are might those be, Mr. Tibbles?
I believe, Mr. Williams, that those relate to constitutional questions relating to...
And I think you're exactly right about that. While I think you likely have a very valid argument on the First Amendment issues, because off-premises signs are, by their very definition, content-related. And as a general rule, you can't regulate the content of what a sign says. But that is beyond the scope of our jurisdiction. That's for the man sitting up on the bench wearing the black robe.
Yes, sir. I understand, Mr. Williams. Thank you for your time this evening.
But one of the, you said that, I think another grounds of the appeal was that Ms. Austin didn't have the authority to deny the appeals?
Well, I believe that is a ground stated in there, and I believe that it had to do with some of the transitional matters that may have occurred when Mr. Greenway was going from the zoning administrator position to the county administrator position. And so I think that the ordinance was clear on who has the grounds and who has the authority to issue those decisions. I think it's unclear to us at what point in time she assumed the role that's defined in the CDC as the person who makes these decisions. And if
well, now, Ms. Austin isn't the director, never has been. And the code clearly says the director makes these decisions, but the code also clearly says that the director may assign responsibility for implementation and interpretation of this code to the staff.
And perhaps that's what happened, and perhaps that assignment was made and we haven't seen it, but perhaps it does exist, and maybe it can be an oral assignment. I don't know.
Okay. All right, thank you.
Thank you, Mr. Williams. Thank you, ladies and gentlemen.
Mr. Chairman, Beaufort County has...
Can you come to the podium?
My name is Tom Kevaney. I'm with the County Attorney's Office. The Beaufort County has retained Scott Bergtol to represent it at this hearing.
Okay, thank you.
Scott is a member of the Bar of Tennessee. He's been admitted pro hoc vici through our state Supreme Court, and he's representing us in U.S. District Court with Adams. He's also representing us soon, I think, in Circuit Court. Pro hoc vici is not necessary for him to appear here, but I'm providing that to you just as by way of information regarding Mr. Bergtol's background. Okay?
Thank you.
With that said, is it all right that I appear before you?
Yes, sir.
Thank you. I'll just take what Mr. Tibbles said and start from there. I think the chronology that he gave was mostly accurate. I think one thing that is not accurate is the claim that on June 24th, when they finally got around to submitting more complete applications, and those were reviewed by the zoning administrator, that they were denied under the old ordinance. That's not true. They were denied under the new ordinance, under the South Carolina pending ordinance doctrine that's been established in many cases and recognized by the South Carolina Supreme Court. The two leading cases from the South Carolina Supreme Court on that, or one is the Court of Appeals, one is the Supreme Court. The Court of,
Versus
yes. The Stratos is the Court of Appeals case from 1989, and Sherman versus Rivas from the Supreme Court in 1979. And basically, those establish that when a public body has intended to consider zoning amendments and they have issued notice of publication, done publication notice that they intend to take those up at a public hearing, that the ordinance is then pending and operative against any application that comes in after that point in time. And in this case, according to what Mr. Tibble said, that the county council had first reading on May 24th, and then on May 25th, the public notice was published in the paper, and that is correct. And then there were 11 applications that came in after that point in time. One of those 11 came in on May 27th, and the others came in on June the 1st. And so the pending ordinance and the ordinance that is now part of the permanent ordinance in the county, the Community Development Code, is the one that governed these applications. In fact, many of the letters of denial referred to sections and provisions that exist in that new ordinance. So it was very clear that when the zoning administrator was acting, that she was acting under the new provisions that had already been noticed for public hearing in the paper. The second thing that I would say is that as to Mr. Williams' question to my opposing counsel concerning the authority to sign the letters, he was correct. Community Development Code Section 7.5 60A3 specifically gives the authority to the director to assign the responsibilities for various development duties in the department to staff, which has been done here. Obviously, Ms. Austin's been before you. She's been in her role for some time. She's issued many denial letters, and that subsection 3 of that section of the Community Development Code specifically pertains to one of the things that the director can delegate to staff, and that is dealing with sign permits. And that's what she did in this circumstance. In fact, the definition of director in Article 10 of the Community Development Code refers to the director or his designee. So there's no problem with who executed the letter. I will note, however, that it bears observation that in this particular appeal, there is no dispute about the grounds that were given. As Mr. Tibble said, the denials were, for all the signs, were based on the same grounds. And they were that they were seeking an application or a permit for a type of sign that is prohibited under the Community Development Code. They were seeking an application for an LED or digital display sign that was in a location where a digital display is not allowed. It also these applications sought to erect freestanding signs that have a height and a width that are much greater than what freestanding or pole signs, which is one kind of freestanding sign, is allowed to have. The application was also denied. These applications were also denied because there were false answers given on the application. Some of those refer to, give us the phone number for the property owner, and it showed that there was a different property owner. Adams didn't own the property. This is true of 10 out of the 11 sign permits. But they basically gave their own phone number. And then another one of the questions on the application queries whether there are other signs on the property. because that would relate to, whether additional signs are allowed and density and so forth. And in all these applications, the applicant said not applicable or no, or something to that effect. But then upon further review, it turns out that there are signs pre-existing on those properties. So there were a lot of determinations made by the director, and that's in your packet before you. And I just want to point out that in the appeal document, there's no claim as to any of those factual grounds. In other words, none of the appeal is based on the idea that the director erred in her determination or in her application of a standard under the Community Development Code, which is, of course, what the Board of Zoning Appeals is supposed to be looking at, is whether she erred in the application of a standard. And there's no assertion that she did. The only three grounds for appeal is that she didn't have the authority to sign the letter, which is the designee of the director, and as the longtime zoning administrator, she does have that authority. And then number two, they claim that the ordinance is unconstitutional, which of course is beyond the purview of this body. And then number three, I will note that in the application packet, they say if the ordinance is deemed to be constitutional, then we want a variance, and we're entitled to a variance under Community Development Code 7.2.140. The problem with that, of course, is this is an appeal of a denial. And you can't say, in my appeal, as an alternative, give me a remedy that has a whole separate process. Of course, there's a whole process, as you are fully aware of a variance. It's a separate form. It goes through separate staff review and determination. None of that's happened here. So it's improper procedurally under the Community Development Code to try to assert a variance application in the middle of your pending appeal. And so that should not be taken up by this body procedurally. But with those elements and the fact that none of the factual grounds or bases for the denials of these 11 sign permit applications are challenged in the appeal, we ask that this body would affirm the zoning administrators and, as the designee of the director, her decisions to deny these 11 applications. Thank you.
Mr. Spurlock, if I may, at what point did the new, well, so you're saying that denials are all made under the new then pending ordinance that had not been finally adopted by the county council?
Right. It was finally adopted, I think, on July 23rd, but
So tell me, when did that ordinance become pending? Because
on May 25th.
Because the staff write-up says, when these permits were denied, county council had voted and approved first reading of a text amendment to Divisions 5.6 sign standards, Division 7.2.40 sign permit, and Article 10 definition. At that time, county council also enacted the pending ordinance doctrine for this text amendment. What does that line mean?
That means that the county council adopted on first reading the draft ordinance, and the very next day they had published in the paper the notice of the public hearing that in fact occurred on June 14th. And under Revis and under the cases and the federal case, Covenant Media of South Carolina versus City of North Charleston, all those cases say the same thing, is that is the point that the pending ordinance is operative.
So you're saying that there wasn't an affirmative act by the county council that, as the staff write-up said, enacted the pending ordinance doctrine for this text amendment?
Well, the county council doesn't enact anything when they do a pending ordinance. It's by operation of law when they have evinced an intent to modify the zoning ordinance and they have published.
Other municipal bodies have clearly, they have passed resolutions invoking the pending ordinance doctrine with respect to certain, but I don't know if you know the history of the pending ordinance doctrine, but it was made up out of whole cloth. And an attorney in Charleston, who was the city attorney for the city of Charleston at the time, made it up, and the state Supreme Court bought into it. And I think it's a totally specious doctrine. It's definitely in the state law. I think it's subject to being overturned at some point, but because it clearly flies in the face of the principle that an ordinance isn't an ordinance until it's finally adopted. But that being said, it's out there, but it wasn't clear to me that objections were under the new ordinance, so I'm glad you got that clarified for us, so. But are there some of the provisions in the new ordinance that are the same as the provisions under the old ordinance that would, if applied under the old ordinance, also justify denial of the sign permit? For
Yes,
example,
sir.
the height
Yes,
and
sir.
the width restriction.
Yes, sir.
So there-
For example, just there's a lot of things that are pre-existing in the old ordinance that are also in the new ordinance, like the designee language for the zoning administrator or for the staff of the director. Also, the size and height and dimensional requirements, those didn't change with the recent ordinance that was adopted and noticed for public hearing.
So is the point there that regardless of whether you look at it under the old ordinance or the new ordinance, the denial was justified?
Yes.
Okay, thank you.
I'm glad you said that because my question was going to be very similar because with that being said, if we're looking at some of this same information that's in the old ordinance and the new ordinance, then, you know, it really wouldn't make a whole lot of a difference, I guess, because you're speaking somewhat of the same language. As far as sign size.
Yeah, as far as sign size, as far as prohibiting certain types of signs, yes, there's analogous circumstances in both the old ordinance and the new ordinance. But according to the pending ordinance doctrine that Mr. Williams elucidated and may not like or may disagree with, but it is the law in South Carolina. Once they, on May 25th, published the notice of an intent to hold a public hearing on June 14th. As of May 25th, that's when the ordinance became operative as to any application. And one of the leading cases, which is a billboard case called Covenant Media, it was a similar circumstance where that notice was published in the paper to hold a public hearing on the zoning text amendment. And then 2 days later, some applications came in and the federal court said, no, that new ordinance applies. But you're right. These applications would have been due to be denied under the old ordinance or the new ordinance. But in this case, they were denied under the new one.
Okay. I only seen one application.
I think there were two in our package.
I sent all 11 of them. That's why the package was so big.
Oh, that one. Yeah, okay.
Maybe
okay.
some more going around.
I'm just looking at the one that's on.
There were only two in what I've received.
I sent you 2 packages. Everybody receives about 2 packages filled with applications for the casket and these signs, signs. I sat at the table and I did that, and there were 2 envelopes, each of you.
Okay.
And if I may approach, I know that oftentimes the body will vote at this juncture and then they will take up a written decision later. But because of the nature of this appeal, that there were really no factual determinations that were asked, that this body was being asked to make, I did prepare a written decision that basically lays out the grounds. If I could approach and give these to you.
Yes.
May I just respond briefly? I haven't seen Yeah, I'll give you a copy, and it's basically identical to the letter. It's basically the ground.
Can I respond very briefly?
As soon as he gets there.
I'm not finished. So as this does, these 7 bullet points are the 7 grounds that, as Mr. Tibbles indicated, are the grounds laid out for the denial of each of the signs. It shows that the hearing was held on today's date. The applicant was provided notice by mail on August 5. And then there's a spot to put in where the applicant either did or didn't attend the hearing. Obviously, Adams did attend this hearing and they were represented by Mr. Tibbles. Someone could put that in there. And then after hearing the evidence or reviewing the record, the ZBA finds that the applicant's not eligible for the sign permits for the reasons given in the development administrator's letters. And since there's been no argument on any of these 7, it would be like a checkbox or a check on each of these 7. I will note one thing, and I don't know if Mr. Tibbles is going to bring this up. There was one, there's a footnote at the bottom of the page. And at the hearing, we are withdrawing the ground for denying the sign permit pertaining to 3589 Trask Parkway, the specific ground, one of the 7 grounds, 7A, which referred to requiring the property owners number being falsely answered because the phone number for Adams Outdoor Advertising, not the property owner. We went back and we looked at some further records, and that is the only property that Adams actually owns the property also. So that 7A ground of denial in the 3589 Trask Parkway that ground is being withdrawn at this time. But other than that, we would just ask that this body basically check those 7 boxes and fill this out for today for the written decision. That just saves the hassle of going back later and preparing a written decision beyond that. I'll give one of these to Austin. And then I'll be available for any. Thank you.
Thank you. Good approach.
I would only say in response that it wasn't clear to me that the grounds were under the pending ordinance, and I think that's improper, and I would incorporate that as a ground for appeal today, because Mr. Williams, as you said, this is I know the case, Sherman versus Revis. I know the lawyers, Bill Regan and Francis Cantwell.
And Francis.
They were city lawyers for decades in Charleston.
Yeah.
And they, it is a fiction that the courts have created to basically say, if you've got a situation where there are pending applications, where there's a pending ordinance and applications are filed prior to third reading or second reading or whatever it's required to enact, then it's not very fair or equitable to say you can sneak in right before the law changes. And here is a little bit different because the applications were pending before the first notice even started the process, before the first public notice. And so I think there's two things wrong with the grounds stated in each of the letters of the 11 denials. Number one, it is a misapplication of the pending ordinance doctrine, because until it is actually enacted, until it becomes law, until it receives the process that everybody understands and the county understands is due process, then it's not law. It's not law until it's enacted.
Well,
Yes.
I don't mean, are we agreed that these applications are all for freestanding signs?
Yes.
And they all had a height higher than 10 feet?
Yes.
They all had a width of more than 15 feet?
Yes.
So they don't comply then with the existing ordinance?
They would not have complied with the existing ordinance in those respects.
Isn't that legitimate grounds to deny the applications?
That would be, I'm pointing out what I believe is a technical error in the denial letters.
All right, but you.
And I would also say that just along those same lines, the applications were pending at the time that the first, before the first public notice of the ordinance change. And so because the applications were pending first, the pending ordinance doctrine doesn't even really apply.
Agreed, but if they didn't, if the signs don't comply with the physical dimensions of the existing ordinance,
Then
isn't that legitimate grounds to deny the application?
then we have problems anyway.
Yes.
Thank you,
Thank
Mr.
you.
Williams.
According to the procedures of the CDC, under 7.3.70C, the appeal is limited to the appeal document that they supplied and any argument on the grounds that they advanced. They did not advance that ground. You can't come to the hearing and add a new ground to your appeal under the Community Development Code. So trying to add an argument against the pending ordinance is just not a grounds that you can add at the hearing. The second thing that I would note is that there was no pending application. They submitted some incomplete applications, but they got a response on April 27th, I believe, from the zoning administrator laying out all the things that were incomplete about their application. So then when the public notice was printed in the paper about the new ordinance on May the 25th, it wasn't until after that on May the 27th for one and then June the 1st for the remaining 10 that applications came in that were actually ultimately denied. And those are the only by the
Mr.
way.
Berthold, if there are grounds under the existing ordinance to deny it, why do we even need to get to that point?
Well, I just want to correct the fact that he's trying to argue that the pending ordinance doctrine doesn't apply because there were pending applications. No, the zoning administrator had resolved the incomplete application. She had sent back 11 letters saying to each one which was incomplete. And then the new applications that basically came in June 1st were after the pending ordinance had already been noticed in the paper. So I'm just correcting a factual fact. But you're right. Substantively, they would both be due to be denied. Thank you.
Thank you. Any more questions for any of the, from anyone for any of the applicant or the county? All right. Well, based on what we've heard today from both the applicant and the county,
Mr. Chairman, if I may, but based on what we've heard today, the information before us, the application before us, the arguments of counsel, I would move that we uphold the administrator's decision to deny these applications on the grounds that they do not comply with the freestanding sign dimension requirements in CDC section 5.6.120.
Second.
we have a motion on the floor.
Second.
Ms. Hughes has seconded. All in favor of denying the application for the signs, could you please signify by raising your hands? So all in favor? Your application has been denied, and I'm quite sure the county would, instruct you in what you should do from this point. Thank you for your time.
Thank you.
Is there any old business?
That's our rules and procedures.
Our rules and procedures? You still dealing with that, Mr. Chair?
I mean, I don't have anything to say other than I think the changes in the proposed rules are warranted. I think it'll help people understand how we run our meetings and what's expected of applicants clearer. And I'd move that we adopt the revised rules of procedure that are before us.
Yes, sir.
I'll second that. I read them and,
Yeah. So it's been, our new rules and procedures have been, a motion has been on the floor to adopt them, and it's been seconded. All in favor of, signify by the right hand, and it's been, everyone is in favor of it, so that those new rules and procedures will be adopted. Any new business? Go to number 10. Can I get someone to adjourn?
So moved.
Second.
Properly made and seconded. We are adjourned until our next scheduled meeting.
Thank you, Mr. Chairman.
Thank you, sir.